on Facebook Live. If you are tuning in via our YouTube channel, just leave a comment. And also for everyone, we'd love to hear where you're calling in from today, the industry that you're in, and what you're most looking forward to hearing about. Thank you.
Hello everybody, it's Damin Murdock speaking. Daniel, welcome from Canada. Linda, hello. What I want to do first is make sure everybody can hear me. So if you can hear me, please say yes. All right, this is our fourth webinar during this COVID period. For those who were present at our last webinars, I would like to know who my audience is, so please let me know if you've heard one of these webinars before. At the end of March, we did a webinar at the very beginning talking about potential payments that the government will be offering, which ended up being the JobKeeper payment. We also did a very comprehensive employment law seminar. So if you're interested in employment law, you can probably go back to that webinar from March, I think it's around the 27th, to deal with employment law. After that, after the JobKeeper payments came out, it was still just announced. So we did our second webinar around the first week of April. And in that one, we focused on, again, the JobKeeper payments and the announcements that had come forward, and also back to employment law and Australian consumer law, dealing with what to do in circumstances where you're selling goods and you have been frustrated by way of your supply chain failing or so on because of COVID. The next webinar, we talked about OH&S, Occupational Health and Safety. That was on the 9th of April. And that was fairly comprehensive of looking at the duties and obligations between the employer and the employee and the OH&S requirements and what you need to do to ensure that your staff are taken care of from working from home or coming into the office. And if they're coming into the office, what you need to do to make sure that you're compliant and are able to force your staff to come in if you need them to come in to do their duties. And now today, we're talking about the actual law that's finally passed. We did on the 9th talk about the law that's passed, but since then we've also got access to more information. And as this continues to develop, with more information becomes more questions. And so we are going to go through and focus on the most recent updates to the law and what answers we can now give that people had before, and what questions we now have because we haven't got an update on it. But my last 3 webinars, I kept on getting the exact same question over and over and over again. I probably got the same question about 20 times. And I want to clarify this right now before I start. And that is, I was saying that the JobKeeper payment only applies to someone who is on the payroll, recorded as an employee, and was paid and tax withdrawn from their wage pay-as-you-go. That has been updated, and that's not 100% correct anymore. They have now defined someone as an eligible participant, which is a shareholder or a partner or a director of a company or partnership. And there is a possibility for that individual who may previously not been recorded as an employee, but who is now recorded as just a director working the business, they are going to be eligible for JobKeeper, and I'm going to go into that development. We also have some retail tenancies developments, so we're going to get into that. Now, my name is Damin Murdock, so if you've already heard me before, you know a little bit about me, but I have been running my own firm for many years. We have an office in Sydney, we have an office in Melbourne. I'm legally trained from Queensland. I'm admitted in all 3 states, and I can advise on all the laws across the country. Despite my accent, I can't advise on Canadian law, but I am Canadian, but we do have American lawyers as well who work with us, and we do work in America a little bit. Now, we've been working with LawPath for many years. Since around 2014, when they first started, we have been working with them, assisting them with developing the different programs that they offer and to get to where they are today. And they, in turn, have been helping us as well. So what we're going to focus on right now is residential tenancies. This is new. We haven't talked about this before. And even though residential tenancies doesn't necessarily deal with business, it is across the board relevant for everybody who lives here in Australia. So I'll touch upon that high level. Now, obviously, I can't deal with every state, but there are similar laws across all the states. Although Queensland seems to have gone rogue a little bit, and there is some debating going on up there about what the tenancy laws are going to look like during this COVID time. But the structure is residential tenancies, commercial leases, changes to the Fair Work Act, update to the JobKeeper and Seeker payments, looking at employment law again, implementing remote working from home, and some of the other legal requirements about redundancy. I will not be going into the depth that I've gone into previously, so I will skip over some slides. I've added some slides here to deal with the new issues. So if you've already heard about JobKeeper, but you're only interested about the updated JobKeeper aspect, then you can log out of this webinar and come back and watch the webinar and skip ahead to where you see the slide that says JobKeeper Payment Update. But let's begin. So as you know, this is not legal advice, it's general advice, it's always changing. If you require specific assistance, feel free to contact LawPath. They have over 1,000 lawyers on their platform who you can contact and ask questions about. And we are one of those lawyers. So if you were to pay for the legal advice plan, which is unlimited phone calls with lawyers on any new legal question for up to 30 minutes. And you can talk to myself on any of the stuff that I'm talking about today or one of my colleagues. Residential tenancies. I cannot deal with Victoria and Queensland and Western Australia and everybody else because this presentation would go on forever. Having said that, what I can do is just focus on New South Wales at the moment, and by way of analogy, it's almost identical. It's very similar in every state, and because it's similar in every state, this is a high-level, I guess, model of what's being implemented, and you can go to your website in your state from your government and walk through the steps. But the steps are going to be very similar to New South Wales, and maybe New South Wales might have gone above and beyond some other states. And if that's the case, you can go and use their template. So let's just look at residential tenancies very quickly. They put a 60-day stop on all evictions. That's basically, let's maintain the status quo. Let's figure out exactly what's going on, and let's not make anybody homeless at the moment. Let's make sure we're able to do this smoothly and get everything in control. So that's the first thing, no evictions for 60 days. And it can be extended up to 6 months. But this only applies in circumstances where you're an eligible person. And to be an eligible person, you actually have to qualify. So the step one is, do you qualify for a stay in the evictions? And that is, if you have a shared accommodation, then one or more rent-paying members of a household have lost their employment or their income. So they've been stood down, they've been made redundant, they have been put on the JobKeeper payment and been reduced down to the $1,500 a fortnight, or alternatively, they have reduced their hours because they're sick from COVID-19, or the above factors all mixed together has resulted in your household losing 25% income. And so that's the first thing to look at is, has your household reduced their income by 25%? Step two is the government has created templates that you can use. And the templates that you can use are on the website. There's links in my slide that won't work because you're streaming it, but I'll get LawPath now to actually grab those links and update them into the chat so you can click on those links. But the links are found at the Office of Fair Trading website. They have created template letters that you can send to your landlord. And those template letters essentially say, I've been stood down, my wage was X, it's now Y, I am kindly asking for a reduction in my rent. Are you able to assist me? Then they have created a template letter for the landlord to write back. And that template letter says, well, thank you very much. Can you please provide me with evidence to support what you're saying? Now, there's a difference between all the different states, New South Wales, Victoria, and Queensland. Queensland is trying to pass legislation that says that the landlord's not allowed to ask for your financial information, whereas Victoria says, if New South Wales says, if you want to actually benefit from this legislation, then you're going to have to be able to prove it. So the landlord can write back and say, okay, yes, thank you very much. I do accept your reduction of rent. Your household income's gone down by 25%. I'll reduce your rent by 25%. But you got to remember, from a landlord's perspective, they also have a situation where they might have a mortgage. So if they're going to reduce the rent by 25%, then they might need help from the bank. So there's then another template letter on the Office of Fair Trading website, and I'll get LawPath to maybe get access to those templates and maybe distribute it afterwards so you have them. But there's another letter for landlords that write to their bank, and it's a template letter saying to the bank, my tenant has asked for a discount in rent, and because of that, I am now asking for a discount in my mortgage. And a lot of people will then say, well, if I am a landlord, do I just get a discount in a mortgage? And the answer is no. You're not going to just get a discount to your mortgage. It's going to be a deferral. It's going to be a stay on interest payments. And whether the question then is, are you going to end up having to pay extra interest as a result of the staying? It does depend per bank, and I can get into detail if you are a landlord and you have questions. Feel free to call LawPath and I can answer those specifics separately if you would like. But if you are unable to reach an agreement between the tenant and the landlord because the landlord, say, can't get a reduction from the bank or the tenant's just simply flat out not agreeing to reduce the rent, then the tenant can make an application to the Office of Fair Trading and they can file a complaints form, which is again provided in this link. And if after that it's still not resolved, you can go to NCAT. Now, I mentioned Office of Fair Trading here, but if you're in Victoria, it would be Consumer Affairs, and instead of NCAT, it would be QCAT, and in Queensland, it would be the Office of Fair Trading, and if not there, it's QCAT instead of NCAT. And so each state has their own tribunal that deals with it. I believe in Western Australia, it's the Magis Court, and same with, I think, South Australia. But Queensland, Victoria, and New South Wales all are Consumer Affairs or Office of Fair Trading. There's a lot of information there. And you try to go through the dispute resolution process through them. And if you can't resolve it then you go to QCAT, NCAT, or VCAT, who all have the exclusive jurisdiction of tenancy law in residential tenancies. Now, the next one is there's been a lot of updates to commercial leases. And so the rest of this presentation is now going to be focused on, I'm running a business. I just want my answers regarding my business. That was more of a side spiel about individual circumstances, but we'll now get into businesses generally. A lot of people have watched our previous presentations. I think we've had about 1,600 for each webinar that we've had, or somewhere around there, but we don't get a lot of likes. And we don't get a lot of thumbs up or thumbs down, but if you do like it, it'd be great to get some likes, some shares, and show us that you're actually interested in what we're saying. And make sure you ask questions, because that's what this is primarily about, is giving you an opportunity to ask specific questions and us being able to answer those questions so that the general public has access to those answers and don't need to call up lawyers and just get some guidance at this time. So the Prime Minister had issued the National Cabinet Mandatory Code of Conduct. And what that is, it's dealing with SMEs and commercial leasing. A lot of people have been stuck paying their rent, and a lot of people have simply wrote to their landlord saying, you know what, I can't use my office anymore because now I am working from home, so I'm not paying you anymore. If you're a small business and you just decide not to pay your landlord anymore, this code won't apply. So you have to be very careful in the actions that you take, because if you fail to comply with the code, then you're going to fail to be protected by the code. So simply deciding not to pay a landlord is not the right answer. You've got to follow the step-by-step process that exists and the recommended actions to be able to benefit from the benefits that are given in this code. So the purpose of the code, it's talking about good faith negotiations. It's nationwide. It's basically saying between the landlord and the tenant, we want to be able to negotiate between each other. We can't pass legislation that deals with each and every situation, but we can pass a code that everybody should be complying with, and that's why it's mandatory. And if the tenant, like the small business, just simply decides not to comply with this, then they're not going to be protected by it. I repeat that because a lot of people are just simply cutting their landlords off as a first step to cut their overheads, and that might not be the best situation. The second thing is that it only applies to eligible employers who have JobKeeper payments. So those who are eligible for JobKeeper. So if you don't have a turnover in a reduction in turnover regarding your revenue, and you do not or are not eligible for JobKeeper payments, and this code's not going to apply to you. And this code is only during the pandemic period, which is defined by the legislation. And if you have a look at the most recent legislation dealing with JobKeeper payments, that's going up to the 1st of October. Before it was the 1st of September, but it took about a month for everybody to draft the legislation and get it passed. So now that pandemic period is going to the 1st of October. So the overarching principles work together, facilitate normal trading or the resumption of normal trading once we come out of the pandemic period, forcing discussion, good faith negotiations, being open, honest, and transparent. And a lot of people that I've talked to don't want to share their financial information with the landlord. And they're saying, well, I want a reduction in my rental payments, but I don't want to show them what I'm actually making. And if you can imagine being from a landlord perspective and you have someone saying, I don't want to pay anymore, a prudent landlord would obviously ask for evidence that you have at a reduction, and there is a requirement to show that reduction. So the actual principles themselves is a landlord must not terminate the leases during the pandemic period due to non-payment of rent. That's step one. Step two, the tenant must remain committed to the terms of the lease, subject to any amendments that might happen as a result of a renegotiation, such as deferment or waiver. And there's a difference between a deferment and a waiver of the actual rental payments. And the landlord must offer tenants proportionate reductions in rent payment. So if the revenue has decreased by 50%, if your turnover is decreased by 50%, then the landlord should be giving you a 25% reduction in rent and a 25% deferral to a later date. And that agreement should be put in writing. And obviously not every landlord is going to simply agree to that. And there is no requirement for a landlord to agree to that unless the proper steps are followed. And obviously the landlord's going to need to get some rental relief or some mortgage relief from the bank to be able to do that. Otherwise, the landlord will clearly be put in a financial hardship themselves and not be able to make their mortgage payments. But what this code is doing is it's putting a positive obligation on the landlord in a situation where a tenant has says, look, I can't pay the entire amount. Can I get a 20% reduction? It's now putting an obligation on the landlord to contact the bank and saying to the bank, look, my tenant has just requested a 20% reduction. Can you please reduce my mortgage by 20%? Now, there are some landlords that will never ask their landlord or their bank to do that. And that's when you start escalating it further. If the landlord simply doesn't want to do that because it seems to be a burden to them, well, they will find that they will be in breach of the code and they will start having the matter escalated, and there will be room potentially to bring this to court or to a tribunal to enforce the code, because the tribunal or the court will be looking at reasonableness. Did the landlord take reasonable actions to comply with the code, or did they flagrantly infringe the code on purpose simply because they did not feel like offering any discounts? The other principles are dealing with amortizing the actual deferrals over a period of time. So they say that if they decide to waive a percentage of the rent, a waiver means you never have to pay it back. It's a reduction of your rent. And then a deferral is where they reduce your rent now, but you'll have to pay it back later over a period of time. And the principles are saying you don't have to pay it back right when the pandemic period ends. It will be amortized over a period of time, and they're trying to get it to be drawn out for a period of time so everybody can get back to normal and not have a massive expense right when they're back to work. And so I lay out all these leasing principles. Hopefully you have an opportunity to have a quick read of them. I'm not going to go through each one of them specifically because I did do this in detail at the last webinar. But one thing to make sure is that the landlord's not allowed to charge you interest or penalties as a result of the deferral payments taking place. And they must not withdraw or take from your bond or your bank guarantee or your personal guarantee. And if you still can't get a resolution with your landlord after trying to negotiate, and you can use the similar templates that are available on the Office of Fair Trading website to use this for commercial leases as well. If you still aren't able to resolve this, then you can proceed to a mediation with the Office of Fair Trading or Consumer Affairs, depending which state you're in. And still, if you are still unable to get a resolution or a reduction, and your landlord is not acting reasonably, you should contact a lawyer immediately, and that lawyer can then have a look at whether the lease is being breached by the landlord. So for instance, if you have a retail lease and the shopping center has been closed, then you don't have quiet enjoyment to your premise, and therefore the contract's most likely frustrated. And therefore you might be able to get out of your lease completely. There are other things that lawyers might be able to do to help you in this situation, such as drafting some letters and making an application. If it's a lot of money, you can be talking about the Supreme Court application to freeze certain payments or seeking a rental abatement, getting court orders, and so on. Let's have a look now at Fair Work Act and the act that's now being passed that amends the Fair Work Act. So as I mentioned before, employment law, we went into great detail about redundancies, standing people down, reducing the wages, reducing the hours, the award rates, things like that. So you can go back to the other webinars to have a look at them. We have had some technology issues in the past with our webinars in the sense that they cut out in around an hour. And so a lot of our webinars are in two parts. So you can have a look for part 1 and part 2. Now, Section 789GB have been inserted into the Fair Work Act as a result of the bill that was passed last week or on the 9th of April. And what that says is that people are now given or employees are now given unpaid pandemic leave for up to 2 weeks. So in our employment law webinar, I said that if someone was sick and has already used up all their sick leave, and maybe they've already used up 3 months or been sick for up to a period of 3 months, there is a situation where an employer can terminate the employee for using up all their sick leave and being sick for 3 months over a 12-month period. They've now essentially extended that 3-month period by saying, well, the employee will get an extra 2 weeks of unpaid leave. So not only do you have to use up their sick leave, they also have to use up their unpaid pandemic leave as well when having consideration to that 3-month period. Now, a lot of people have asked about annual leave entitlements, and when calculating the JobKeeper payment of the $1,500, does that include annual leave entitlements? I'll clarify that question in a bit, but if you ask that question, you know what I'm talking about, and I'll answer that in about 10 minutes. But if you look at the Fair Work Act, it now entitles employees to request to have their annual leave paid out over an extended period of time. So if someone had 2 weeks annual leave saved up, they can now have that pay dragged out over a 4-week period instead. and that just basically drip feeds them a little bit over that period, so that it goes over a longer period, and it might also assist with an extra pay on top of the JobKeeper payment. The amendments to the Fair Work Act has also resulted in an amendment to the Fair Work Act, but in turn it also resulted in an amendment to 99 modern awards. And so a new schedule is being automatically inserted into all of these modern awards that deal with these changes. 99 of them. And one of those is being allowed to reduce an employee's full-time employment down to 22.2 hours, reducing a part-time employee's employment 60% by what they were before, and only giving 24 hours notice, which was previously 14 days notice. And there's also an ability to do a stand down, which is get them to perform alternative duties. Now let me just have a look at what the next slide deals with. Okay, so I'm going to go back to this point because there are a lot of unknown questions or a lot of questions around this. So I just want to expand upon this a little bit right now. I have seen a lot of people, first of all, telling employees, look, we can't afford to pay you your salary anymore. We're going to reduce your salary now by 20%. And but we still want you to continue on working the normal hours that you were working. And if you continue working the normal hours you were working, then the business will be back up and running quicker, and you'll be back onto your normal salary. From my perspective, that's unlawful, and you can't be doing that. If you're going to reduce somebody's hours, or if you're going to be reducing someone's salary, you should be reducing their hours as well. This Fair Work Act amendment only applies to JobKeeper eligible employees as well. So you have to show there's a reduction in your turnover, entitling you to JobKeeper payments, to then be able to, in turn, reduce your employee's wage and stand them down. Now, you then have, you kind of split off into two different avenues here. Avenue one, which is, okay, I don't need my employees on a full-time 9 to 5, Monday to Friday basis. So I'll reduce them to from 38 hours down to 22 hours, and I'll reduce their salary down as well to reflect that. That's allowed. You can go down that avenue. The other avenue is saying, I still actually need them to work the hours they're working, but I don't want to pay them as much. That is not allowed, but it can be done if you make them redundant. And the way you would do that is you would say, look, because of operational changes, our turnover has dropped significantly. We've reduced our salaries, or we reduced our turnover by 30%, and we can no longer afford to pay our staff the salaries that they were on. And so although you were on a salary of $80,000, there's no more position in that sales role for $80,000. I'm sorry. So this position is now being made redundant. However, we are in a position to offer you a salaried role in the position of sales person at a $50,000 or $60,000 salary. And if you wish to accept that new position, then you can. And if you were to do that and the employee accepts the new position, then you're allowed to keep them working the hours that they were working on a reduced salary. It's obviously a very technical situation because you got to make sure you implement the redundancy correct, and you got to make sure you have legal basis to be implementing that redundancy. And you got to also remember that if you make that offer to the employee about the redundancy and they don't accept that new role, you then have to make them redundant. You then have to pay them out their notice period. You then have to pay them out their annual leave entitlements. You then may also have to pay them out their redundancy pay if you're if you're not a small employer with more than 15 employees, or if your employee is under a modern award that has a redundancy pay, such as the building construction award. And you also open up yourself to a potential unfair dismissal claim. So if you we're going to require your staff to continue on working the same hours, but pay them a lesser amount, that's unlawful unless you're making that position redundant. And if you're going to make that position redundant, then I suggest you get some legal advice on what to do, or go back to my previous presentation, I think on the 27th of March, that deals with that whole process. Now let's look at the JobKeeper payment. Again, a lot of people are here for this. If you've been in this webinar before, in the past 2 webinars, we've already dealt with JobKeeper payments. We're going to talk about the updates in about 5 minutes. I'm going to go through this fairly quickly so that you can just get to the new updates. In terms of all your questions, I'm going to be answering those at the end as well. And normally we get about 200, 300 questions. So normally we go for about 40 minutes talking about those questions and answering them. And we will get to every question shortly. But going back to the JobKeeper payment, it only applies to certain situations, which we'll get into. We'll go through the 4-step process. But we had a bunch of questions after it was first announced to when it was passed and to now. And so some of the common questions we're going to answer are the reduction of hours, whether the employers can reasonably stand people down, and how do they actually direct people to be stood down, and the fact is that they still have to comply with the Fair Work Act. So staying within this realm is really important, and following the procedures is really important. So step 1, we've only dealt with small, quote unquote, small employers who have less than $1 billion, because that's our target audience. So if you have less than $1 billion turnover, and your turnover has fallen by 30% when comparing it to a typical month, and this is what the announcements were, and this is what the bill says, over 12 months. And as you can see, this is an old slide, and it says that the law had not been enacted yet, but essentially what it means, it doesn't mean necessarily you had a reduction of 30% from March 19 to March 2020. What it actually means is they look at a high level of whether you've actually reduced by 30%. And the ATO has made it very clear that they're going to be very flexible in doing this. And so they said they want to look at, they don't want to necessarily have you look at March 19 and compare that to March 2020 or April 19 to April 2020. They want to take a higher approach to that. But the legislation as passed today does exactly that. It compares March 2020 to March 19. It compares April 2020 to April 19, and I'll go through that. And that's exactly what the legislation says. So in this slide, it says that that's not what they're going to do. They have actually done that. However, that's what they call the basic test. And then they have another one called the alternative test. And the alternative test hasn't been passed yet, but looks like there's going to be about 4 different alternative tests. And those 4 different alternative tests is basically going to be based on what the ATO said they're going to consider. So although right now it's not the just straight up 30% or it's not the high level difference, and it's strictly the 30% reduction from year on year, they are about to change that or implement new alternatives tests for you to look at. So what that means is we highly recommend, if you think you're going to have a downfall of 30% or your business is being affected by COVID-19, we recommend you register. Registration opened on the 20th of April. You have to make the $1,500 payment to the staff, which I'll get into. But we recommend you register. We recommend you take the money. And if you find out afterwards that you didn't qualify, then there's always opportunity for you to pay back that money at a later date. But this is about good faith and doing the right thing. And if you really believe that you are probably suffering as a result of COVID-19, then you're probably going to be eligible under one of the future alternative tests that they're about to implement. So looking at that year on year from March 2020 to March 19, if your turnover is reduced by 30%, you're eligible under the basic test, which is the new law. Number two, the ATO will consider if you're significantly affected, which is pretty broad. And they also say that they're going to have discretion when having consideration to special circumstances, and they're going to have tolerances when having a look at good faith and whether you did it on a good faith basis, and just whether the turn down generally has adversely affected you. So this is such a broad test, so that the fact is right now under the basic test, you might not comply. You might not have been operating for 1 year. You may have only been operating for 6 months or 4 months. I would recommend you still apply. And this is because you're probably going to get captured by one of the alternative tests that are going to be coming in momentarily. Now, once you decide whether you're an eligible employer by acting in good faith and looking at the numbers, then the next one is you got to look at eligible employees. Now, an eligible employee is someone that was on the books on the 1st of March, and even if they were terminated afterwards or made redundant, you can still re-engage them and bring them back and put them back into the company for them to be an eligible employee. And if they were a part-time employee, they apply, they're eligible. Full-time employee, they're eligible. Casuals who have been employed for more than 12 months, they're eligible. After my last webinar, I got a lot of questions about what we call transferring employees. So let's say you have a holding company and your employee was employed by your holding company, and then you created a subsidiary and you transferred all your employees from your holding company down to your subsidiary. Technically, they haven't been employed by the same entity, but if you have not paid out all the employment entitlements at the time of that transfer, they're going to be deemed a transferring employee, and they'll likely qualify as a 12-month employee if they've been employed by the group, holding company and the subsidiary for a period of 12 months. Same thing applies when there's been a merger and acquisition or a purchase of a business. If you've acquired a business this year from somebody else and you've transferred the employees across, if you look at the Fair Work Act, you have transferring employee definition. Basically, the legislation for JobKeeper has taken the same definition from the Fair Work Act and has put it into here. And so that's basically saying a casual who's been on a regular basis for more than 12 years or 12 months. They must be over the age of 16. They must be a permanent resident citizen special visa category holder, or a New Zealand citizen under visa 444. Now, we did talk about this before. They have expanded the definition. The definition now includes a director or shareholder of a startup or of a company, and that's going to be very applicable to listeners today. Before I said that if you're not on the payroll as an employee, you're not going to be eligible. However, they have changed that, and I'll get into that in about 1 minute. But it does not apply, and it still does not apply to temporary visa holders, 457, 482, sponsored visa skilled migrants, and spouse visa employees, and so on. And it does not include a self-employed person, it does include a sole trader, but there's an extra step that they have to comply with. The way you get access to this is you make your application and you must pay your employee $1,500 every fortnight. So this is a fortnightly payment. So my understanding is that you would have had to pay between the 1st and the 14th of March to be eligible for the first payment of $1,500 per employee, to be eligible to the first payment, and so on moving forward. So if you're on a monthly payment, I think you might have to talk to your accountant in getting through that process. to show that you still should be eligible, even though you're not paying them fortnightly as the legislation says you must be doing. So you got to apply to be a JobKeeper eligible company, and then you must be an eligible job or an eligible employee, and then you must pay that employee $1,500 per fortnight before tax, and you must apply, and you must get your employee to complete their form as well. And for you to get paid on the 1st of May or the first week of May, all those steps have to happen. Payment of $1,500, you applying, filling out the paperwork, each employee who you nominate filling out the paperwork as well. And then you will get a cash payment in your bank account. It's not a credit. So let's just walk through how it actually works. So the purpose is for people not going to Centrelink and getting the employer to deal with this kind of pay. It's a subsidy to the employer. So if you normally pay an employee $3,000 a month, or sorry, if you normally pay an employee $1,000 or $3,000 a fortnight, then you continue to pay them $3,000 a fortnight, and the ATO will refund you $1,500 as a subsidiary so that your payroll is half for that individual. However, if you normally pay someone $1,000 a fortnight, you have to top them up, and you have to make payment of $1,500, and then the government will pay you $1,500 back. You only have to pay $1,000 on your on the normal pay, but the extra $500 that you've had to top up, you don't have to pay super on. Now, a lot of people are going to say, well, I have someone working $3,000 a fortnight, and it's great that the government's giving me $1,500 back, but I'm still out of pocket $1,500, and that employee isn't working in the business, and so I'm slowly diminishing all my resources, and I'm losing money, so this isn't good enough. Well, if that's the case, then you're left in a situation where you need to negotiate with the employee to see whether they're prepared to stand down, take annual leave, take sick leave, stand them down the hours that they're working, don't pay them, reduce them down to the $1,500 a fortnight so that you're not out of pocket for keeping that employee on board. But if you were paying them $3,000 and now you're only paying them $1,500, that means their hours should also reduce by 50%. So if you're going to reduce the salary by 50%, the hours should reduce by 50%. And if you don't want to do that, and you don't want to reduce the employees' hours by 50%, but pay them half of what they were getting before, then you're probably going to have to go down the redundancy and redeployment avenue, and you got to be very careful about how you're going to do that. Now, this is the updated definitions that we want to get into, and this is specific to whether a director of a company is entitled to the JobKeeper payment, or shareholder is entitled to JobKeeper payment, even though they're not on the payroll. And the fact is that even if they're not on the payroll and they're not deemed an employee, they are entitled to the JobKeeper. And this is different to what we were saying before. And because they saw that gap and they fixed it. So clause 12 of the rules that I've mentioned up above says that there's a definition of an eligible business participant. And that is an individual who is not an employee of that company or any company who is paying them JobKeeper, so they can't get JobKeeper from two different locations. So it's someone that's not an employee for this one entity, satisfies subsection 2, which I'll go to below, but it's basically been working in the business, and is not excluded, and there's some exclusions, which I'll get to in a second as well. So essentially, for 9 out of 10 people, it's if you were a startup, you didn't have an employment contract, you didn't have enough money to pay yourself a salary because you were waiting for the revenue to come in, but you've been running your business, you've been participating in your business, you're an Australian citizen, permanent resident, not a 457 visa holder, not a 444 or not a temporary resident holder, but are eligible to JobKeeper payments, then you will be able to nominate yourself as an additional JobKeeper person under the definition of eligible business participant. And that specifically, and they've set out a table. So if you're a sole trader, you're going to be, rather than an employee under the JobKeeper employee definition, you're now what they call an eligible participant. And if you're in a partnership and you have two partners who are taking distributions from the partnership but weren't on the books as an employee, then they're going to be an eligible participant. Same thing with a trust. Now, let's be careful about the trust, because if we go back, the business must be carrying on by the entity. So a lot of people have this corporate structure where the company has a director and a shareholder, and then the company is the trustee of the trust. If the corporate trustee has been trading in the business, then you're going to be eligible on behalf of the trust. But if the corporate trustee is just holding shares in another business, you're not eligible because the trust was not trading. It has to be the trading entity. And then the other eligibility is if you were a shareholder or a director in the company, but have been actively involved in the business, over the age of 16, comply with everything else in the previous slide, and you're Australian resident, which basically means what we're saying before: special visa holder, not a temporary visa holder, citizen, permanent resident, special visa holder, New Zealand citizen under a 444 visa. Now, the process in terms of the nomination is you're only allowed to nominate one person in your company as an eligible participant. So you might have 2, 3, or 4 directors who were all actively involved in your startup, and they were all working in the business. You can't all get it. As far as we understand, you can only one person get it. Look, you can share it amongst yourselves afterwards, but you can only get one person. Same with the partnership. So you can get all your employees the JobKeeper payment, but eligible participant is only limited to one per entity. And you've got to nominate that person. You've got to give notice. That person can't be an employee. And they must satisfy all the requirements. And the exclusions are someone that's receiving parental leave can't get it, and someone that's already incapacitated can't get it, on-comp, workers' comp can't get it. And so they're trying to make sure that if you're entitled to another government incentive or Centrelink payment, then they don't want you to be able to double dip. Now, again, the law's changing. There's alternative tests coming in. There's changes to the definition. So we're just updating you on what we know right now. I do see that Heather has said she's been on the phone to the ATO, and she believes that the eligible participant might apply to more than one person. As far as we're aware, at the moment, only one eligible participant can apply in the company. Now let's look at that turnover test that we were talking about. This is the definition, so the 30% reduction. The definition is we look at your GST turnover. So what have you been paying year on year, quarter on quarter for your GST? And they look at the relevant comparison period, and they give the example explicitly what I said wouldn't necessarily be the right method. Well, this is the legislative method. Look at March 2019, compare that to your April 19, and when you, or look at your March 19, and when you compare the two periods, if your GST turnover is reduced by 30%, you're now an eligible employer under the JobKeeper payment. And there's an example there that they provide in the rules. But that's essentially all we have right now is the basic test. However, I said before, they did mention over and over and over again that they're going to be very lenient. They're going to be looking at it. They want people to use good faith, and they're going to be discretion and all this other stuff. Well, this is what they've done. They've created what's called an alternative test. And the alternative test is basically saying the commissioner can decide whatever they want later. And the commissioner may, by legislative instrument, determine an alternative test. And that's all we know right now. What it means, who knows? What it means is probably what they've already put in writing to us, to everybody, saying, we want you to act in good faith. You must have effects to your business that is likely going to result in a 30% reduction, and that they're going to be using their discretion in determining that. So this is the alternative test is the legislation that's passed to delegate the commissioner to pass new tests without having Parliament go and sit down and debate an alternative test. It's a quick revenue, or it's a quick way to pass the alternative test, and it's delegating that power down to the commissioner of the ATO to pass new tests. And we're keeping our fingers on the pulse there, making sure that the minute those tests are passed, you guys know about it. But it's highly likely it's going to be similar to what we presented before. Now, a lot of people get confused about the JobSeeker and the JobKeeper payment. We're going back to a situation where an employer isn't eligible for JobKeeper. What do? They have to make someone redundant. They have to terminate someone's employment. While at the end of the day, they are still entitled to a JobKeeper payment. And we thought it's kind of relevant for employers to know that they're not going to be left in the lurch without anything. They're going to still have something. And so we thought it's important for you to know what the JobKeeper payment is. And the JobKeeper payment is where the employee has been stood down. Your employer or the employer is not eligible for the JobKeeper, so they can still collect Centrelink via JobSeeker. So employer can't prove the reduction in turnover. The employer can't afford to pay the $1,500 requirement to enable the payment from the government because they don't have the cash flow to be able to do that. Then that means that the employer is not an eligible JobKeeper employer, means that in turn the employee is not an eligible JobKeeper employee. Therefore, that payment or that scheme doesn't apply, so they can go on to JobSeeker. And JobSeeker applies in a situation where someone's just been stood down. You've stood down an employee, you've reduced their salary by 20%, you've stood them down 100%. In that situation, they can still get a JobKeeper payment and still be an employee with your company, just not receiving payment. So that is let's say, for instance, you are in retail, you have no turnover at all, your business is dead in the water at the moment, it's been put in what they call hibernation. You still want that employee to come back the minute you start up your business again, and you're not eligible to JobKeeper, so you stand them down and you send them off to Centrelink. And because their wage has dropped below 20%, and because they're now earning less than $1,086.50, they're now eligible for the JobSeeker payment. There is some other requirements which you can have a look at, such as the income threshold, whether your spouse is making alternative income. This was discussed previously, and the government websites answer all those questions pretty concisely. Going into just leave generally, back to employment law, and I'm about 5 minutes away to finishing this up, but let's just look at a following employment law, because you still have to follow employment law. And all the amendments to the Fair Work Act and all the changes in the commercial leases, those only apply to JobKeeper eligible companies. So if you're not a JobKeeper eligible company, you got to revert back just to the Fair Work Act. And even if you are a JobKeeper eligible company, you still need to know what the employment law is generally. So let's go over that quickly. If you're going to force a close down of your business, then you got to decide whether your employee is on a modern award. If they're on a modern award, most modern awards have in Clause 8 the requirement to consult. Clause 34, forcing individuals or employees to take annual leave and being allowed to pay out an employee early. I've seen this in Clause 34. I've also seen it in Clause 24. It varies. If your employee is not on a modern award, then you've got to revert back to the Fair Work Act. In Section 94 of the Fair Work Act says you can force people to take annual leave, and that specifically is in Section 94. And you can force them to take under annual leave in a situation where it's reasonable. No doubt COVID-19 is reasonable. If you want to stand down some employees and not others, such as you're not receiving any phone calls now, so you're going to stand down your sales team, but you want to get phone calls, so you're going to keep your digital marketing team, then you got to be very careful on who you're choosing to stand down. And I normally recommend a matrices to be developed with columns and rows saying down the columns, these are the employees. So going down, these are the employees across. This is the commencement date. This is the roles and responsibilities, job title. This is the salary that they're on. This is their duties. This is the change in duties. This is why the change in duties are required. This is the other duties that we have considered what we could put them into, but we can't. And therefore, we're now making a proper decision on who we're standing down and who we're not. And it's not discriminatory. It's not done wrongfully. It's done for a legitimate purpose after you have done your proper analysis on who to stand down and who not to stand down. And that's how you will be required to get over the reasonableness of standing down certain people, not others if you go across the board. What if someone tests positive for COVID-19? As I mentioned before, they get an extra 2 weeks of unpaid leave. They have to use up their sick leave. If they've used up their sick leave, they've used up their pandemic leave, and they're still sick and they're still not coming back to work, but they had COVID-19 and they can't work from home, then you can still keep them on unpaid leave. And they have to be sick for a period of 3 months over a period of 12 months, excluding any legitimate absence. So the 2 week pandemic leave and the sick leave is legitimate absence. So it has to be a further 3 months above that. Now, I've talked about working from home before. LawPath has a working from home policy. If you haven't implemented it yet, it's about time you do so, because it's been like 5 weeks and you should do it. And the reason you should do it is because there's going to be a lot of things that you need to do to comply with OH&S law. So if you end up having someone work from home who ends up having a psychological condition or illness because of them being isolated and you not looking after them, then did you comply with the OH&S requirements? Someone has carpal tunnel because their desk isn't the height of their chair, or they're working on their ironing board because they don't have a table. These are things that you need to make sure that you have complied with, and your working from home policy will go through that, and it deals with setting other KPI requirements, keeping monitor of people, and it also is just a good policy to have, just generally, making sure you're doing the bare minimum. Redundancies. I've talked about this before at length, but you don't have that gap to continue on paying your employee, even though they are even though you're eligible for JobKeeper. So take a step back. You have a 30% reduction. You're eligible as a JobKeeper. Your employee makes $3,000 a fortnight. You're only getting $1,500 from the government, and therefore you have a gap of $1,500. You can't afford to pay that $1,500. You don't need to make the employee redundant. You want to probably, for the best interest of that employee, reduce their hours and their wage in proportion so that their salary is brought down to the $1,500, and then keep them on the JobKeeper payment, but not require them to do the full hours that they normally would be doing. Alternatively, if you're in a situation where you're a JobKeeper employer, you don't have the ability to keep an employee on their $3,000 salary, but you want them to keep on working at the 38 hours that they're doing, then there is a possibility to make their position redundant and redeploying them into a lesser role. But if you're doing that, you got to be very careful, because you're basically saying, I don't need you to perform the role on $100,000 that you were making before, Monday to Friday, 9 to 5, but now I need you to perform the exact same role, Monday to Friday, 9 to 5, on a $70,000 salary. Now, that's hard to fathom by an employee saying, why am I doing exactly what I was doing before and now I'm getting paid less? And the reality is that an employer is allowed to make someone redundant on grounds of operational changes. And operational changes can mean a reduction in their turnover. So even though you don't have a reduction of 30%, you might have a reduction of 15% or 20%. And that would give a legitimate reason for you to reduce the salaries within your company. And you essentially go and say, well, this is the offer. You have two options. I'm going to make your position redundant because I can't afford the $100,000 anymore. And instead I'm offering you $80,000, and I'm offering you that $80,000 because our turnover's dropped by 20%. And you have two options. You can accept this new role at the lesser pay, or number two, be made redundant. And you then leave it with the employee. And if the employee chooses to accept the new role, they then only have 21 days to file a claim in Fair Work. And if they don't, they should be statute barred from an unfair dismissal claim. So it gives you some certainty really quickly that they're not going to come back after you later for claiming that they were forced to accept something less. And you having a Fair Work Ombudsman issue of underpayment of employment entitlements by unilaterally changing the wage without an actual written agreement. So that's the situation where you'd make someone redundant. Or the other situation is you just simply don't need that role anymore. So have a look at the redundancy presentation that I did, the first one in March. I go into redundancies a lot, but it has to be a genuine redundancy. If it's not a genuine redundancy and you're not taking reasonable steps to redeploy the employee, then you're in a situation where you'll fall foul to the Fair Work Act and you could have an unfair dismissal claim against you. And if an employee just simply refuses to come back to work, then you should be issuing, as long as you've followed all your OH&S laws, which we outlined in our 1st or 2nd of April presentation, as long as you followed everything there, then you give a demand, written warning to the employee to come back to work. And if they still don't come back to work, then you consider dismissing them. There's also changes to the Corporations Act in relation to debt recovery. There's different changes to Australian consumer law, like force majeure and company guarantees, or Australian consumer law guarantees to services and guarantees to goods. We go through that, such as situations where you can't comply with your contracts and what you should do to protect yourself now that you're breaching delivery dates or breaching whatever it might be, holding events and so on, in breach of your contract that you might have with somebody. And there's a lot of other schemes. There's $250,000 loans available. There's instant write-offs available. There's pay-as-you-go as cash assistance, which is one of the best for the money that you withhold from your staff's salaries. You can get that back as a credit later, up to $100,000. All right, now let's get into questions. So as I mentioned before, if you like the presentation, great. Give me a thumbs up. If you didn't like the presentation, then don't give me a thumbs down. Just walk out. I've got a lot of it's okay, but a thumbs up or a smiley face would be a lot better. All right, now let's get into your questions. So Sam says, going back to retail tenancies, is there a start date for the 60 days? I believe it's just started. I don't have it in front of me. I believe it starts on the 9th of April, but don't quote me on that. Maybe LawPath can jump on to the Office of Fair Trading website and see when the 60 days starts and post that here. But I think it's I think it's around the 9th of April. If not, it should be now. Going back to residential lease, if a tenant and a landlord agree to a rent deferral, so that a rent deferral is saying, I don't have to not pay my rent, I'm just going to pay it back later. Actually, no, what they're saying is that deferral is actually, so AB, that the proper definition of that is actually a waiver. So they're reducing their rent, so it's waiving, but accumulate the variance for the tenant to pay back later once the tenant situation is better. Okay, no, that is a deferral. So a waiver is reducing the rent. You never have to pay that back again. Deferral is reducing the rent and then pay it back later. So the question one was, it's not actually a question, but I think it continues on. So then we have a second follow-up from AB, which is here. What happens if the tenant finishes the lease? So they've got that waiver or the deferral, or they got the deferral, they owe money. They now finish the lease and simply decide not to pay the debt back. Would the landlord hire a debt collector to follow that up? How should the landlord do this? So you should have a written agreement. It's a debt just like any other debt. I would, if you're going to enter into an agreement with a tenant, and that agreement is to allow for a deferred payment, I'd be making sure you get all that information so that you can find that tenant later. Obviously, the residential address is the current location, but I would be getting their mobile number, their email address, maybe the address of their employer, name of their employer, possibly parents' details if they're younger, and their address, somehow to find them. Because what happens after that is you can bring a claim for a small claim in NCAT, QCAT, VCAT, Majees Court, small claims court, and you can sue as a debt, just like any other debt. And when you do so, though, you got to be able to find them, and you got to be able to notify them. Now, if they've disappeared, quote unquote, and you can't find them, you can then apply for what's called substituted service. And substituted service is going to the tribunal and saying, well, the last known email address was here, and I sent it to this email address. The last known phone number was here, and I called them, and I talked to them, and I told them I sent them an email. I also sent them a text message or her a text message to this address. I've also sent it to the employer, and the employer's confirmed they work there. I've given them notice. They know about it. Now I want to prove that I've served it by way of personal service, and you can get an order for substituted service to find them and then go after them just like any other debt. And the tribunals are made for individuals to go for small claims. So if it's less than 10K, it's going to be fairly easy for you to try to do it on your own, and you probably don't need a lawyer involved. The next one is the retail tenant's not paying the rent and not responding to emails or call. That means that they're not complying with the actual COVID code. They are flagrantly breaching your residential tenancy agreement. I would be sending them a notice and a text. I would send them an email. I would explain what the code and what the rules are in your state of what they need to do if they actually want to stop paying rent. I would tell them that they're in significant breach of their lease. I would tell them that they will not receive any protections under the current law because they are flagrantly infringing the tenancy lease, and therefore the protections will not apply. And then send a text message to their phone number, tell them you sent an email. And if they don't do anything, I'd probably consider going straight to the tribunal to get an eviction, or referring it to go to Fair Trade or Consumer Affairs or your local small business commissioner that can deal with that to get a mediation immediately. Maybe they're not even there anymore. Who knows? The next question is from David. If 8 staff are voluntarily offered a temporary 20% reduction in pay while applying for the JobKeeper to keep things going, and they accept it, if we do get the JobKeeper, should the employee's pay be put back to normal, or can we wait until the 6-month period is up, and then we can reassess the pay cuts later? Or is this completely unlawful? It's what most employers are doing, but it is unlawful. It is saying across the board, look, we have problems in our business. We don't know what the problems are right now. We need to make sure that we can continue on employing everybody. We're going to make an offer to everybody. Take a 20% reduction. And it's across the board for everybody, including the management. And if you all accept it, then in that circumstance, we will put you back to where you were once the COVID period or pandemic period is over. And if everybody does not accept it, then we have no choice but to consider making certain positions redundant. So you're basically putting on your staff saying, let's do this together. Let's all agree to work together. Let's all take a cut. Now, that's what a lot of people are doing. Even the big companies out there, the blue chip companies are doing that. The big law firms, the big accounting practices are basically saying, you automatically opt into a 20% reduction unless you don't, which is you automatically are going to accept a 20% reduction. And if you have a problem with it, call us and you opt out. It's unlawful to do that. You're unilaterally changing the employment terms of an employee. So what I would be recommending you do is you definitely 100% get it in writing. It's really a redeployment into a new role. And if you're comfortable with using the wording you're being made redundant and you're being redeployed into a new role at a lesser salary, then I'd be using that definition, because if you have problems or someone doesn't accept it, then they have 21 days to file a claim against you, and you'll know that rogue employee within 21 days. If you simply do it as a across-the-board acceptance, then you're opening yourself up to a possibility where you could get a claim in 6 years from now from the Fair Work Ombudsman saying that you unilaterally changed the terms of the employment. If you lock it down now as a redundancy on new terms at a reduced salary and redeploy them into that new position, they're statute barred. They can't do anything about it after 21 days. And if they want to make a complaint, they have to do it in 21 days. And in that situation, it's very hard for an employee to bring a claim when they're statute barred. I would think that they have to have exceptional circumstances. So if you put something like, go get your own independent advice or something, or you've done this willfully, then you should be okay. Just going through any other questions. If not, we will call this a wrap. And if you enjoyed this webinar, then give us a thumbs up, share it with your friends. Thank you very much. And that's it. And if you have any questions, feel free to contact LawPath. Thank you and goodbye.